Hi there, I'm Lucy Whitaker, a specialist motoring solicitor at Pragma Law in Nottingham, and today I'm going to be talking about what a single justice procedure notice is. Now, it's a relatively new method of instigating legal proceedings against an individual or a business. It was introduced in 2015 to enable a single magistrate sitting with a legal advisor to deal with cases in the absence of a defendant. And they're used regularly for motoring offences such as speeding, no insurance offences, failing to give driver details and others. And this video is a general overview of what they're used for, and I'm not going to go into detail about the legal requirements of the form and the content of the notice, or indeed the timescales, but I'm planning on making another video on that in due course. So when you receive a single justice procedure notice, you have 21 days to respond to it. You'll be required to indicate whether you're pleading guilty or not guilty to the allegation. And if you're pleading guilty, then you have the choice to either plead in writing, by post or online, or to request a traditional court hearing before magistrates. If you plead not guilty, then the matter is usually listed for a trial where you can put forward your defence. Although the single justice procedure notice was created to be used for defences which can be dealt with in the absence of the defendant, it appears they're still routinely sent out for offences for which a traditional court hearing would be more appropriate. Very often defendants will plead guilty to an allegation, asking for it to be dealt with in their absence, only to find that the matter is to be listed for a court hearing and then they've got to attend. Now, the main instance when this happens is when the court is considering disqualification, either because of the seriousness of the offence or because of the number of points already on that person's licence. If a court is looking to disqualify someone either because of the seriousness of the offence or the number of points on a licence, then the defendant has to be warned about it before it happens. Driving whilst disqualified is a very serious offence for which a person can go to prison, so it's really important that the defendant is on notice that they may be disqualified before it happens. Sometimes the single justice procedure notice will include witness statements, and the paperwork will ask you to indicate whether or not you require those witnesses to give evidence at court. If you intend to plead not guilty, then it is far better to seek advice at an earlier stage. There are strict time limits and procedures that must be adhered to if you intend to put forward a defence, and you may find yourself at a serious disadvantage if you don't know what you're doing. The Crown Prosecution Service, who deal with defended allegations on behalf of the police, are experienced lawyers, and you don't want to lose your case because you don't understand the procedure or the law. Even if you intend to plead guilty, it's often best to get some advice prior to doing so, because a good solicitor can help to mitigate the circumstances of the events and keep the ultimate penalty to a minimum.